Welcome to this explainer, folks. Today we are stepping right onto the tactical battlefield of South African civil litigation. If you've ever wondered how legal battles are truly fought and won behind the scenes, well, you are in the exact right place. We're going to unpack a mechanism that is as powerful as it is misunderstood. Okay, let's dive right into this. How do you actually win a lawsuit without even arguing the facts? Usually when we picture a trial, we think of witnesses, dramatic evidence, and arguing over who did what to whom. But what if you could bypass all of that? What if you could stop a lawsuit cold without ever having to defend the actual merits of the case?
Here's our tactical roadmap for today. We'll be looking at 1. The strategic procedural weapon. 2. The not right now defenses. 3. The case killer defenses. 4. The structural blueprint. And finally, 5. Deploying Rule 33-4. Don't worry, we are going to demystify this highly strategic procedure logically.
All right, starting with Section 1, the strategic procedural weapon, bypassing the substance. Picture this. You're a defendant, and you've just been served with a summons. Now, you essentially have a choice in your strategy. A standard plea? Well, that's your frontline combat. That's where you're fighting the actual substance and merits of the case, saying, hey, I didn't breach the contract, I actually delivered the goods. But the special plea, that is your absolute secret weapon. It completely ignores those core merits and instead throws up a technical, legal, or factual obstacle that sits entirely outside the main argument.
Now, the dynamic here is absolutely crucial. You can't just point out a typo and call it a day. To actually use a special plea, the defense you're raising doesn't appear on the face of the plaintiff's summons. That means you, as the defendant, literally have to introduce new facts to prove why the case just cannot proceed. And if you nail this, you have the power to delay, freeze, or totally kill the lawsuit right out of the gate.
Moving right along to Section 2, the not right now defenses, also known as dilatory pleas.
Now, what's really interesting about this slide is that a dilatory special plea acts a lot more like a stun gun than a fatal blow. It doesn't destroy the plaintiff's claim permanently. Instead, it basically just puts a temporary freeze on the litigation until a very specific condition is met.
Let's crack open this Category A arsenal. First up, arbitration. You hit the plaintiff with this if your underlying contract explicitly demands that disputes go to private arbitration first, rather than straight to the High Court. Second is lis pendens. You'd use this if the plaintiff has already sued you for this exact same issue in another court, and that case is still active. I mean, they can't fight you on two fronts simultaneously, right? And third is locus standi, which basically means the plaintiff simply lacks the legal standing or right to sue you in the first place.
To really ground this concept of locus standi, let's look at this example. Imagine your neighbor suing you for a debt you owe to the local supermarket. It's totally absurd. Your neighbor has absolutely no legal interest or standing to collect that specific debt. That is exactly when you deploy a special plea of locus standi to just freeze them right in their tracks.
Which brings us to Section 3, the case killer defenses, or peremptory pleas.
Okay, the stakes are getting higher now. These are the sniper rifles of the legal battlefield. A peremptory special plea strikes a permanent, fatal blow to the lawsuit. If you deploy this successfully and the judge upholds it, there's no temporary freeze. The litigation is completely and totally dismissed. We're talking game over.
3 years. That's the magic number. Under the Prescription Act, standard contractual and delictual debts, things like personal injury or property damage, legally expire after exactly 3 years.
So let's unpack this fatal Category B arsenal. First is prescription. Like we just talked about, if someone tries to sue you 4 years after an incident that has a 3-year limit, you kill the claim with a special plea of prescription. Second is res judicata, which translates to already judged. If a court has already given a final judgment on this exact dispute between the two of you, they don't get a second bite at the cherry. And third is statutory notice failure. Say a plaintiff is trying to sue an organ of state, like the Minister of Police. They absolutely must send a mandatory 6-month statutory notice in terms of Act 40 of 2002 before issuing the summons. If they fail to do that, you trigger this defense and absolutely destroy the claim.
Let's move right into the drafting phase with Section 4, the structural blueprints, constructing the weapon.
Procedurally speaking, a special plea is drafted as part of the exact same physical paperwork as your main plea. But the key thing to remember is that it sits right at the very beginning of the document. The structure follows 4 strict steps. 1. The heading and title. 2. Alleging the material facts. 3. The prayer. And 4. The main plea follows immediately. Let's break those down.
When you're alleging those material facts, you can't just vaguely throw your hands up and say, hey, this claim is prescribed. No way. You have to construct a rigid timeline. You must explicitly state when the debt became due. Then, you cite the specific law, stating the 3-year statutory limit under Section 11D of the Prescription Act 68 of 1969, for instance. Next, you state the exact date the summons was served. And finally, you draw the mathematical conclusion proving the period objectively exceeds 3 years.
And this brilliantly illustrates Step 3, the prayer. Every pleading needs one. It's the conclusion where you explicitly tell the judge exactly what order you want, stating, "Wherefore the defendant prays that the defendant's special plea be upheld with costs, and that the plaintiff's claim be dismissed with costs." You literally have to ask for the victory.
But right below that prayer, you absolutely must have Step 4, the transitional heading, Defendant's Plea on the Merits. This is your crucial safety net. Without waiving your special plea, you proceed to answer the actual facts of the case paragraph by paragraph. Why? Well, because if the judge disagrees with your secret weapon and your special plea misfires, you need your frontline combat troops ready to go. You definitely don't want to lose the entire war just because your initial tactical strike failed.
Now for the grand finale of our explainer. Section 5, Deploying Rule 33-4, Tactical Execution.
So the crucial point here is clearly contrasting this procedural move with another tool called an exception. An exception argues that the plaintiff's paperwork is legally flawed based only on what is already written in the summons, no new facts whatsoever. But a special plea, as we've seen, brings in external facts, and because it introduces those new facts, it actually requires lead evidence in court.
And that is exactly where the magic of Uniform Rule 33-4 comes in. Think of this as your deployment mechanism. When the matter is set down for trial, parties use Rule 33-4 to ask the court to separate the issues. This basically means the judge will hear the evidence for and decide on the special plea first, completely ignoring the main facts of the dispute for the time being. And this is exactly why it matters. The tactical advantages here are just massive. If the defendant wins that separated hearing on the special plea, the court dismisses the case right there on the spot. You avoid a lengthy, messy trial on the merits. This saves everyone months of stressful preparation and saves thousands upon thousands of rands in trial costs. Seriously, it's efficiency and strategy at its absolute finest.
Which leads me to leave you with this final, somewhat provocative thought to wrap up the explainer. If a single procedural move can kill a case before the facts are ever even heard, are lawsuits really won on the truth or on the strategy?